Hi, this is Rain. Sounds like Rain. I'm a Minnesota licensed realtor helping families get through probate with more money and less stress. Today, I'm joined by Minnesota attorney Bob Everhart from the law office of Robert J. Everhart. Bob brings over 35 years of legal experience with a background in bankruptcy and real estate law, and that gives him a unique insight into estate planning and probate. Bob, please tell us a little bit about the services you provide and what drew you into estate planning.
Well, my first job out of law school was at a title company, so I became very adept at title examination and identifying title problems. From there, as an attorney, I enjoy fixing title problems. Part of that was dealing with people in foreclosure, and that led me into practicing in bankruptcy law. And after a number of years, the stress of dealing with people in financial distress was getting pretty heavy. So I moved on. There's a lot of common themes in bankruptcy and in estate planning. So it was a natural progression there. It's nice now to be the fire inspector rather than the firefighter.
hmm Absolutely. And that's one of the things I love about your background is kind of that blend of the estate planning, the probate, and also foreclosure. Online, we do get a lot of questions about probate and foreclosure and a lot of false assumptions, in my opinion.
Yes,
And so I am going to have definitely some questions about foreclosure and probate. But
sure.
but before we go there, um, just talking a little bit about avoiding probate or how to proactively avoid probate. I also get a lot of questions from people that want to know how they can avoid probate. In many cases, it might be after someone passed away. But when we talk about the importance of planning ahead, what are some of the some of the most effective strategies that you advise people on when it comes to avoiding probate?
Is to really think about what you want to have happen to your property when you pass. And I would say in 95% of the cases, they just I want things to be as easy as possible for my kids. And as I don't want probate, that's a common theme. Well, if you don't want probate, you need to plan ahead.
hmm
And I recommend consulting with an attorney. My number one tool, I think, is listening, because people do have different goals. Um, Not that anybody wants this to be as painful and expensive for their children, but the opposite, and that takes planning. In most cases where you own a home, you have a couple of adult children who all have their own homes, and they're just going to want to sell the house as quickly as possible and divide up the money and get on with their lives. There's a tool called a transfer on death deed that's very effective um, in accomplishing that goal. As the name implies, it is a deed. It does transfer title, but it only does that upon the death of the owner. And if, for instance, it's a husband and wife who own it as joint tenants, it's after the second death.
hmm
Now, there's a number of really neat features with TODDs. And first of all, being a very easy to remember acronym there,
hmm
Transfer on Death Deed or TODD. But you're free to change your mind at any time up to death. If you decide you want to sell your property, it's no longer a good living situation, you are completely free to do so. If you are of a mind to take out a mortgage, you can do that. If you have a change of mind about who you want to get your house, you can change that, the beneficiaries on the TOD, again, anytime up till your death. Second is the beneficiaries on the TOD have no rights to the property until you die.
hmm
I ran into that in a number of times in bankruptcy where Before there were TODDs, there was transfer your house to your kids and reserve a life estate. You'll avoid probate. Well, it's true, you will avoid probate, but the problem with that is you're actually transferring your house to your kids. You retain the right to live in it until you die, but they are the actual owners. And if they do something like file bankruptcy, they no longer own that interest, and there's a bankruptcy trustee involved. And
Mm,
they're not understanding well, it's not their job to be concerned about the family. They're concerned about your creditors, and they'll force a situation to be bought out, which unfortunately comes as a surprise to people. But fortunately, that's largely a thing of the past now that there are transfer and death deeds. Now, situations where you don't wouldn't want a TOD. One is if, for instance, there's a child who still lives with you, and you want them to continue to live in the house for indefinitely for a set number of years, then the TOD will still avoid probate, but you'll run into, for instance, if there's three kids and one wants to live in it, you're going to run into two kids that probably want to convert that interest into cash and do something with it. A way of avoiding that is to set up a trust, and then the trust would own it so that that too would avoid probate. But then the terms of the trust say, that
mhm.
first child gets to continue to live in the house upon child no longer living in the house, the property will be sold and the proceeds distributed however you want it to.
Bob, can I jump in with a quick question?
Sure.
In the scenario that you just described, where you could use a transfer on death deed or a trust with a child or children who live at home, are you talking about minors, or are you talking about adult children, or either? Or like, can you do a Todd with a minor?
Don't do it. Can you?
Can
Yes.
you? Yes.
Are you going to regret it? Yes.
Okay.
Um, the problem anytime a minor is put in title is that you'll need to have a conservator appointed
Mm.
if you want to sell it before they turn 18.
Oh, okay. Okay.
Now, conceivably, if the kid's 17 and 6 months, that's a risk worth taking. But uh, it wasn't my client, but talking with another attorney who the client had a nephew that she wanted to help build up assets. So she bought some commercial properties jointly with, I think the kid was 8 or something like that.
Mm, mm.
So it's going to, and obviously she didn't intend to keep the properties for over 10 years. So it got to be quite a mess for that attorney to fix for her.
Oh yeah.
So uh, don't, well, and that's another good situation for trusts
Mm-hmm.
because the trust then owns it for the benefit of that child until they reach 18 or even older if you decide.
Absolutely. And my understanding is in Minnesota, was it last year that the Todd requirements changed in Minnesota? And now you
There
can.
was a very, very good question with a very unique problem
Mm-hmm.
there, and that is that because it's effective upon your death, whose insurance covers it after the
Mm-hmm.
death? And you very well may have been paying your premiums, but then you die. Well, you had the insurable interest, and now somebody else owns the property. The change was you do have roughly 30 days to get, or the insurance continues for 30 days, giving the beneficiaries time to get their own insurance on it.
Well, and
And yeah, go
and
ahead.
the other thing I was going to mention with that is, it's my understanding that now if you make a mistake on that deed, they'll still record it, even if it's not accurate. And so therefore, if you're doing this without an attorney trying to save money, just because they record your deed doesn't mean it's going to give you the protection that you're looking.
That's a problem. Yes, there can be very simple errors in the legal description where um, it wasn't the property that you intended to go. It's not the property you in fact own,
Mm.
and you've and one of the I guess one of the downsides of doing title resolving title problems is they always seem to come up, a day or two before closing.
Yeah, yeah.
And that's when you find out that, oops, I made a mistake with the TOD and the person passed away 6 months ago, and that's you're looking at other problems.
And that's when, if they haven't called you yet, they definitely will need to call you at that point, right?
That is correct. Yes.
And
I,
if
I
in
do a lot of talking with closers and realtors as well, because that's
Mhm.
when those problems come up, they come up at the last minute. And
Absolutely.
it,
In fact, that's one of the reasons why I highly encourage people, if you can work with a real estate agent who understands probate, they can have conversations with the attorney and yourself to save you time and money. I also get asked, can an agent who doesn't understand probate handle a probate transaction? Of course, the answer is yes, but they don't know what they don't know, and they might be okay, but they also might run into some of the kinds of problems you're talking about. So,
exactly. And it causes unneeded frustrations and the difficulty between the realtor who's learning communicating with their client that there's nothing wrong going on that the
right,
realtor's doing. They just don't speak the language.
correct,
And somebody who has done work in probate knows the buzzwords.
and the
And
risks, and the risks,
that's right.
and when they become issues. Um, Bob, you also talked a little bit about your experience in bankruptcy and how does that come into your estate planning and probate work? For example, well, maybe that's two separate questions, but I'll let you decide how you want to answer
Okay. Well, one of the um, one of the features of being an estate planning attorney or working in estate planning is coming up with the most bizarre scenarios that people need to think about.
that. Mm-hmm.
And by working in bankruptcies, I have seen what happens after everything falls apart, so that you can think, oh, this might all, yes, if everything works perfectly, that idea will is golden.
Mm-hmm.
If it doesn't, these are the problems that you're going to have. And it may be that you're willing to take those risks, but you need to know that you're taking a risk to make an intelligent decision whether it's worth it.
Sure.
And particularly in estate planning, that the tools needed to avoid that risk are so cheap and easy that it's
Mm-hmm.
really foolish to take the risk.
So just to recap, it sounds like if a family comes to you to do estate planning, there are steps you could take right away that can help family members avoid foreclosure after the owner passes away. I also get a lot of questions from people who have a family member that passed away and they start getting the foreclosure notices. Sometimes they even ignore them. Don't ask me why, but they do
That's
sometimes. And then they come back at the last minute and they say, "Hey, my house is going to be foreclosed upon, or that we had the sheriff sale and I'm going to be evicted. What can we do?" And as a real estate agent, I know there's not a lot I can do. And my number one advice I give them is, let's try to get into probate right away so that you can get your letters and start negotiating with the bank, and also talk to an attorney to see if they can help. Do you have any remedies or suggestions for someone who hasn't yet filed for probate and find themselves right on the verge of losing their loved one's home?
and have they died?
Yeah,
Eh,
yeah,
uh,
yeah. So someone passed away, they stopped making payments, and
sure.
or the family chose to. And the other side of that is, you probably know, some of them think that just because the family member passed away, that they might be exempt from foreclosure. or continuing those payments, and it's
That's
not
a
true.
that's not true. Correct.
Yeah.
And there are different procedures that can be done to delay a sheriff's sale,
Mm-hmm.
um, so that you would be buying some more time to get the probate going and doing it. There are uh, uh, different types of probate for the emergency situation where
Okay.
you everything was going fine for the house sale until the day before closing, the seller passes away. Well, there is
Mm-hmm.
a court proceeding that in relatively short time,
Mm-hmm.
meaning uh, within a couple of weeks,
Mm-hmm.
you could have the authority to sell the house and then do the rest of the probate over a more extended time.
Okay.
Uh, but everything is very time critical, so it's important to consult with an attorney as quickly as possible to know those options.
Absolutely. And the good news is it sounds like there are options if you're willing to consult with an attorney.
Exactly.
And sooner is better than later.
Sooner is better because the flip side is there's options, is that there's time limits on all the options.
Hmm.
And again, if you're ignoring notices, that's not a good strategy.
Yes. Yes. Or I've even seen cases where maybe the family isn't necessarily ignoring the notices, but they didn't realize that the deceased, when they were sick, they stopped making the house payments, and that,
Correct.
I
And
mean, we
there
see.
very well may be a pile of mail with all these notices that are unopened
Oh,
um, in the deceased's desk or something. So it's not casting blame. It's just stressing the importance of legal notices are important. Find out what they are and what they mean to know what your options are.
absolutely. Just one more, or maybe one or two more questions about estate planning. So, when a family, I don't like to call it do-it-yourself estate planning, but I
Sure.
imagine that that happens. What might be one of the biggest mistakes you see families make when trying to avoid probate and not talking to an attorney? So maybe they come to you later and you need to clean up the mess.
Um, I actually um, just had a client that had a contradictory provision in a do-it-yourself trust that he did.
Mm-hmm.
And uh, it's funny, he had a different thing that he needed help transferring his house into the trust.
Mm.
And as part of doing that, I reviewed his trust and pointed out that he at one point says it's to be his estate's to be divided equally among his children. At another place, he says, but this child's to get nothing. I say, well, which is
Oh,
it?
oh.
So we did an amendment, so it clarifies that, well, he had, I think, four children, including the one to disinherit.
Mm.
So it's true, I have four children. These named children are who I intend to benefit, and I do not intend child number four to get anything under this instrument.
Okay. Okay. Wow. That's a big one.
Yeah, so there's obviously unintended wrinkles
Mm-hmm.
where you say one thing in one place and another in another. By hiring a professional, you avoid those. There was a situation where it was one of the do-it-yourself wills,
Mm-hmm.
and it was the person who did it was estranged from his family, had reestablished his life, and had a partner that he wanted to get everything.
Mm-hmm.
So, do-it-yourself will. I give all of my assets, and it rattled off personal property and things like that to partner, but then it had a residual clause that said everything else goes under the laws of intestacy, which those are the
Mm.
laws that
Mm-hmm.
define the family that gets it if you don't have a will. And he happened to die in a car accident, so there's a wrongful death lawsuit. So his property totaled, a couple $1,000, and he had $1 million lawsuit.
Hmm.
Well, the $1 million lawsuit was part of the residue of his estate. So that went to his family, and his partner got his wrecked car and
Mm,
clothes and things. So it was definitely not what he intended. So
wow.
you're in those risks doing it yourself.
Absolutely. And so, and to summarize then, for estate planning, um, people could do it themselves. Um, you and I would both advise they speak with an attorney, or I liked
Right.
your example where someone did it themselves and they still came to you for a review.
Yeah, and
And
I offer reviews of do-it-yourself. I do free consultations
mhm,
at this time. Anyways, just to see. And 90% of the time, there's probably absolutely nothing wrong with what you drafted. But it's those times that there are
yeah,
that defeat the whole purpose of you doing that.
absolutely. Like in that case, you had mentioned that that child that was supposed to be left out might have been entitled to 25% of the estate.
Yes, yes. And
That's a,
and further, it also invites a lawsuit
mm,
but from him saying, well, obviously you didn't intend to exclude me because I was
mm,
included in that part. And you wanted it to be simple and avoid courts. You've just made it so that it will go to court.
absolutely.
I
So
often make the half joke of saying, well, can you do it will yourself? Yes, but you can also service your own car's transmission. I don't recommend it.
that is so true. So for estate planning, you could do it yourself, leveraging those transfer on death deeds and naming beneficiaries and all these other things that could get you below the threshold in the state of Minnesota. You could also talk to an attorney like yourself and maybe still do some of those things. You could also set up a trust. So there are a lot of things you can do in advance to avoid probate in Minnesota. And I've from what I found, it looks like the threshold, every state seems to have their own threshold.
Correct.
And so some of the principles we're talking about, even though we're talking specific to Minnesota, a lot of these principles apply in other states. You just have to look up your criteria and your
Right.
threshold. So now let's talk about navigating probate for the families who were not able to avoid it. And one of the things I found is that um, if a person passes away, if they didn't take steps to avoid probate before they passed away, then it's not likely the family's going to be able to avoid probate as if they meet that criteria.
Well,
Is
if they
that true?
die owning real estate,
Mm-hmm.
it's required to, and you want to sell the real estate, you
Yeah,
have to go through probate.
exactly. Exactly.
And the threshold you were referring to in Minnesota is $75,000. So
Mm-hmm.
if you have a house, you have $100,000 in investments. If you it did it, and then you have your normal household goods, a car, that sort of thing. If you did a transfer on death deed for your house, if you named beneficiaries
Mm,
on your investments, and then the car and household goods is worth less than $75,000, you would not need to go through probate.
absolutely. In Minnesota,
Or
then is that
more
a
accurately, your family would not need to start a probate
sure?
because of your death.
In Minnesota, is that a small estate affidavit then?
Exactly.
Exactly. Okay.
Yes.
And with a small estate, I don't. I'm going to learn something new. And with a small estate affidavit, does the court issue letters of administration, or what happens
No.
then?
Uh, it is uh, it is it well, it is an affidavit
Mm-hmm.
that states certain facts about why you have the authority to make this claim.
Okay.
And I guess stepping back, the legislature decided 75,000 was the threshold. If it's small enough, if it's under that, it's small enough for us not to require a judge to sign off on it.
Oh, okay.
Essentially, that's the difference. So
Okay.
if in that scenario you had $10,000 in a U.S. bank account,
Mm-hmm.
you could do the small estate affidavit, and U.S. Bank would release the funds
Honor that.
to you. And
Oh,
on that,
wow.
you say why. For instance, he did a will. I was named as personal representative. I'm an heir.
Mm-hmm.
That sort of thing.
Okay. So what advice would you give to families to make the probate process as smooth as possible?
Contact the attorney as soon as possible.
Mm-hmm.
The I find that it's really once clients hire me for a probate, basically um, all the work is done behind the scenes. There's not a lot of things that they need to do.
Mm-hmm.
Depending on the type of probate, there may be a hearing that they need to attend. Uh,
Mm.
Currently, that's all probate hearings are by Zoom.
Okay. Yeah.
Um, so that's makes it easier. I do frequently have clients come to depends on their comfort with the technology. If they're not
Mm-hmm.
comfortable, come to my office. You can be on the Zoom call with me on that. The biggest frustration is that the court moves at its own pace.
Mm-hmm.
And I had a relatively simple probate. We filed it in May and couldn't get a hearing until the end of September.
Wow. Wow.
So yes, and um,
Was
there
that
were
in a larger county that was backlogged
that
or
was
a
in
small?
Hennepin.
It was.
That was
Okay.
in Hennepin.
Okay.
Yes. And I don't know right off what you can expect for other counties.
Mm-hmm.
Probably not quite that long, but if it's something where you're wanting to have a closing,
Mm-hmm.
every day is uh, is a burden.
Yes, that's true. Wow. Okay. So contact an attorney right away. Be prepared to file. It sounds like we'd want to file right away so that you can get your hearing and hopefully get your letters as soon as possible.
Exactly. Yeah.
Okay.
There's really in I'm trying to think of a scenario where you wouldn't where I would advise somebody to wait on the probate.
Mm,
Um, if it's a situation where the will named another sibling
mm-hmm.
and that sibling's not acting, I might give
Mm,
them some time to act,
okay.
but in most cases, I guess my first piece of advice will always talk to your sibling
Mm-hmm.
and find out, is there a reason? Are they intimidated by the process?
Yeah.
On that, if it's just, um, I don't believe in courts or something like that,
Yeah.
uh, well, then we're first of all have a formal probate because we may have a fight on who should be the personal representative, but that would be a case. Again, you'd want to get it going because there's really no reason to
Mm-hmm.
delay.
In fact, a similar scenario I see, and I would imagine you probably see it even more than I do, would be the scenario where there was a will, and the personal representative, maybe it's a child who lives in the house, and they plan to continue living in the house. And since the will says they get the house, they just assume no further legal action is necessary until they call me to sell it.
Exactly. I had a case. I was actually with a title company, so I wasn't involved with the case. I surmised that it was a large family with the youngest um, who continued to live in the house for many years, like 20
Mm-hmm.
years after the
Mm-hmm.
parents passed away, but nothing was done. And then that child passed away, and some relatives said we need to sell the house.
Uh,
And there was, I think, like 70 parties to it because there was
oh,
like 10
cousins
kids
and
who all had
yeah.
7 kids who three of them had filed bankruptcy. A number of them had died and had their own
Oh,
probate, all in one huge quiet title action.
wow.
And at that point in time, the attorney's bill was $30,000,
Mm-hmm.
and it hadn't finished yet.
Mm-hmm.
So it's not a simple thing that.
Absolutely. One of the other things I recommend for families to make probate a smooth process is even if they decide to go through probate without an attorney, it's never too late to bring an attorney on board, right? If you start the process and you get stuck, or you just need help with a particular part of probate, do you take on clients like that where maybe they've started probate and then they just find out they need help or they need help with a certain part of it?
Yes, I do. Um, and it's either that, either taking over the entire case
Hmm.
or that there's just one feature. Well, frequently, as we get to closing, and um, uh, I think there's a spectrum with the title companies about uh, who is willing to get the probate documents and who isn't,
Hmm.
and drafting the personal representative's deed and that sort of thing. I frequently get involved with that. So yes, if it's something that, oh, I didn't know I needed a hearing,
Hmm.
now I'm scared. Yes, I'll step in and let you know if there's anything to be afraid of, and if there is, how to fix it.
Excellent. Bob, when we talk about navigating probate effectively and estate planning, one of the things I noticed on your website that I thought was very unique and I wanted to ask you about was membership plans for ongoing support. Um, at first thought, I thought, okay, that probably applies more to estate planning, but could you tell us a little bit about your membership plans and can people leverage those for probate as well?
They uh, the way that works, it's $100 a month,
Hmm.
and it's provides for basically unlimited review of your estate plan whenever you have a question on that.
Hmm.
It also provides for um, uh, you have a question, email me. There's no charge for me to answer it because you've already paid for the plan. It would not pay for an entire probate. That is a separate action.
Okay.
But if it's something of, for instance, uh, my brother is the personal representative of dad's estate, and this is happening. Is that right? Or this is what I'm being told. Is that correct? Those kind of questions I can answer for people
That's
under those
phenomenal.
subscription plans.
So you offer free consultations and you have a membership. It sounds like you have options for people at all income levels, really.
I do. I do. Yeah, it's uh I I have a should turn my camera around on my windowsill here. I have a Gumby doll
Mm, mm-hmm.
and uh and say I'm flexible. Uh and and yeah, it's there's a huge spectrum of people's um uh um needs
Mm-hmm.
and ability to pay for those. And not every case is the Howard Hughes uh, will cases from the
Mm-hmm.
70s that went on for 20 years or something like that. Most of them are fairly straightforward. Um, the but yeah, I realize where people are coming from,
Yep.
and they need some answers, and they need to be able to afford some solutions. So I don't like charging when I can't do something for somebody. That's why I
Mm-hmm.
offer free consultations. So you know what you're getting into before that. I say I'll let you know when the meter starts running, so
Absolutely.
um, it's not a surprise. I
Yeah.
also don't like those surprises, and clients don't either. If there's cheaper options, for instance, as part of discussing estate plans, one documents a healthcare directive.
Mm-hmm.
Many clinics offer those for free, so um, I do tell people that that's available, a way of saving on the expense. I do say the biggest advantage of having me do it is that it gets done with your other documents,
Right, right, right.
which that's a huge problem with healthcare directives, is there's probably more that are in process or sitting on somebody's desk than actually completed. Um,
Absolutely.
but yeah, it's everybody's different, and I'm a true solo, so I only answer to myself uh, for um, for fees and such, so I can be flexible.
Excellent. Bob, I'd like to just take a few minutes here to answer some questions from our probate help desk Facebook
Sure.
community, and you may have already covered some of these. So let's see. First one is, as a beneficiary, what should you do if you don't agree with the final accounting?
That's a tricky one.
Hmm.
Consult with an attorney because there's time limits on when you have the opportunity to object.
Sure.
Be clear about the dollar amounts because those disputes are expensive.
Hmm.
I personally don't do litigation on those, so I would be referring that out.
Okay.
But oftentimes, just a stern letter saying, what are you questioning,
Hmm.
and getting an explanation. Well, that may satisfy why the number is what it is. Um, yeah, so
Well, my follow-up on that is you mentioned getting an attorney. So um, I've seen two scenarios. I've seen one scenario where it's recommended for the beneficiary to hire their own attorney to represent their interests. Um, and then I've also seen other scenarios where the beneficiary will try to go to the attorney who's representing the personal representative. Is it, do we need to make a
that
distinction?
that is a tough
Yeah.
distinction. Yes.
Yeah. Yeah.
In most cases, you can talk to the personal representative's attorney.
Okay.
Um, if it's a question of where are we in the process, um, uh, it's up to the attorney um, the problem for the attorney is
Hmm.
that my client is the personal representative.
Right.
So I represent them. Um, I don't represent you. And if you disagree with what position I'm taking, then you really need to have your own attorney
Gotcha.
to fight it out. Again, in the vast, upwards of 90%, everything goes relatively smoothly,
Hmm.
and there really isn't anything to fight over. So you're wasting your money hiring an attorney if it's not needed. But in those less than 10% of cases where something actually is going wrong, getting an attorney involved, and again, the
Hmm.
earlier the better, is to your advantage.
Absolutely. And I would say, as a person who's had to fill out those accounting forms a few times, even with the help of an accountant and an attorney, man, I'm really tempted to give people the benefit of the doubt on those forms.
Yes, yes,
It can be very tricky and very challenging. Um, uh,
right.
another another question from the Facebook community: when might a judge consider appointing a guardian ad litem?
Those are um, a guardian ad litem. Is the ad litem part is for this case, and it's usually a situation where there's a minor child involved.
Mm-hmm.
And for instance, the in the case that I referred to earlier, where the well-meaning relative put the 8-year-old as a joint owner of a commercial property, if the if there was a situation where they wanted to do something with that property, a guardian ad litem might be appointed to protect the child's interests.
Okay,
And that's in addition to the conservatorship that would be needed.
excellent. Next question from our Facebook group. In Minnesota, are there situations where a personal representative would need signatures from the other beneficiaries in order to sell the real estate?
That, strictly speaking, no. If it's a matter that John Smith owned the property by himself,
Hmm.
it's John Smith's estate, and you know, Jane Smith, as personal representative of the estate of John Smith, she'd be able to sign off to sell it. Where it gets a little iffy is if there's multiple owners,
Okay.
and they might also be beneficiaries or heirs of John
Uh,
Smith.
sure.
They may need to sign off as part of that. Um, Other than that, uh, as far as signing on a deed, there may be something where informal probates, after the distributions, there may be a receipt that you're asked to sign
Mm-hmm.
as a actually you're a devotee, not a beneficiary, but as that saying that yes, I did receive this, yes, I agree that
Mm-hmm.
this is what I'm due, and I'm waiving any other claims against the estate. You may be asked to sign something like that.
Got it. And so the other side of that coin is in Minnesota, once the personal representative has letters from the court, they do have authority to sell the property if
That's
they would like
correct.
to. Okay.
That's correct. And many real estate brokerages will require the letters to be issued before they'll even let a listings agreement
That's one of
be
my
signed.
favorite topics, Bob. That's that's one of my favorite topics. I agree with what you just said, and I wholeheartedly agree with that. And then every once in a while, I'll come across an agent who will take the listing before they have the letters, and you just kind of point out, hey, that contract might not be valid, and
Exactly.
they get really fired up. Not that I would want to take that listing from them, but you know.
Well, and the problem comes up is that as a realtor, you're putting all this work in marketing
Hmm.
this property, assuming that you have a good listing, only to find somebody else gets um, uh, gets appointed as personal
Right,
representative, and
right,
their
right.
spouse
Yeah.
is a realtor. So guess
Yep.
who's getting the listing now?
Yep. I have run into that situation too, where other agents will call me and they'll ask me if I want to partner on a deal, and they want me to come out and talk to someone's mother-in-law just passed away, and the first thing I ask is who's the personal representative. And if they say someone other than that person, I'm like, oh, there's nothing really for us to do there. We can
Yep,
advise them, but that doesn't mean you're going to get a listing out of
right.
it. So, oh, thank you. That's a great answer. One more from our Facebook community probate help desk. And this is, you answered this question, but we're going to put a little twist on it. In Minnesota, is there a way to stop a foreclosure of a deceased person, especially if nobody in the family has filed for probate? And I think you said there are multiple ways that it could be done.
There is there is um, I'm trying to recall what the document's name is, and it's escaping me, but there is a document that can be filed and served on the sheriff and the foreclosing attorney,
Mm.
basically saying don't have the sheriff sale, delay it for 6 months, and then there's a 1 month redemption period after that
Oh,
sheriff.
okay.
So it's kind of
Right.
flips the deals there, and that can be filed. Um,
Can I ask you a
and if
question?
by ch oh,
If,
go ahead.
excuse me, if you file that document, then are you at the mercy of the other attorney or the court? Like, who decides if that is the process that we're going to be allowed to follow then? Does someone in the court have
Well,
to sign off, or just the other attorney
no,
agrees?
it's a right that mortgagors have in
Mm.
Minnesota,
Oh, okay.
and the foreclosing attorneys all know that,
Okay.
and more importantly, the sheriffs know that.
Okay.
Yeah, if they get that, they can't have the sale for that period of time.
That's fantastic. So someone in the family who is maybe going to become personal representative would file that document,
That's right.
and they file with the court, with the recorder, with the sheriff.
Yeah, it's a document. You record it, and then
Mm.
you serve certified copies of the recorded document on the sheriff and on the
Oh, nice.
foreclosing attorney.
Wow. I have a feeling I'm going to be calling you to talk more about that. I
Okay.
may I may have some clients who might need help in that space. So,
Okay. Well, great.
absolutely. Well, those are all of our questions from our Facebook community. And before we wrap up, are there any other tips or advice that you would like to impart on our listeners?
Well, the talk to an attorney early and often,
Hmm.
um, to know your options, know if there is a problem, that sort of thing. And probably even more important than talking to an attorney is talking with your family.
Hmm.
That where there's misunderstandings is uh, when families haven't discussed things. Why did you want my sister to be personal representative and not me? Hearing
Hmm.
it right from mom and dad um, uh, can avoid a lot of, if not actual problems in the probate, certainly misunderstandings and hard feelings.
Yeah. Well, it sounds like it could save a lot of money too.
That too. That too. And some informal advice I frequently give clients is to write a letter
Hmm.
to be given out after their passing if there is something weird
Mm.
um, uh, on that you had there. If
Yeah.
there is somebody that you're not giving a full share to, sort of thing.
That's
Uh,
a great idea. I know in I share stories about my probate situation when I was personal representative, and it was just my sister and I, and we had a lot of conversations about what we each thought my dad really wanted
uh-huh.
because he wouldn't always talk to us about it, or he might talk to us individually and tell us different things.
Yes. Yes.
Having something in writing would have been fantastic.
Right.
That would have been
And
fantastic.
most people I deal with, say, this is unfair, but I know that's what he wanted.
Mm-hmm.
And it's it's what he wanted that matters.
100%. Um, so we talked a little bit about some of the unique things you do, the memberships. You also do free consultations. In a minute, I'll ask how people can get in touch with you. I also noticed on your website that you accept Bitcoin payments. Is
I
that?
do. I haven't had anybody offer to pay me in
Oh,
Bitcoin.
okay, okay.
I take that back. I did have somebody who needed a copy of a document that was going to cost like $25 and wanted to pay in Bitcoin. And I said no to that. But as I said, I'm flexible.
Oh, that's fantastic. Okay. Um, so how would you, we'll put your contact information in the show notes. Do you have a preference on how you would like our listeners to get in touch with you if they have more questions?
Sure. Email works best.
Hmm.
Um, and Robert at roberteverhartlaw.com. I do have a Gmail address, which you may have picked up from a website. Either
Hmm.
one works.
Okay.
Um, feel free to give me a call. The best number is 763-478-7970. Um, but phones being phones, uh, playing phone tags is always frustrating. And an email is easy to answer and clarify details and such.
Absolutely. So we've been speaking with Bob Everhart from the law office of Robert J. Everhart. And Bob, you're a Minnesota attorney here in the Twin Cities, but as we were discussing, you use Zoom, and in Minnesota, you can help people in any county throughout the state.
Correct.
So, and you make it very easy, very convenient, and you offer free consultations and membership. So, Bob, this has been really, really informative, and I really appreciate the time you spent with our probate help desk community. And I just want to say thank you very much for joining us today.
Well, thank you very much for the invitation.